was you must explain who you are and what you've done, so that you can justify to the court that you have the ability and the right to stand and give evidence. So, following that advice, I want to tell you some very brief details about me. I'm a mariner who was lucky enough to become a lawyer. I answered an advertisement by Holman, Fenwick & Willan when I was sitting for one of my tickets, my master's ticket, and they took me on, and I discovered, to my amazement, that there were firms of lawyers who did nothing else but collisions and salvage and things like that. So they sent me to law school, and I qualified, and when I became a partner, I moved to Hong Kong and headed the Admiralty Department of Holman, Fenwick & Willan. And I was in Hong Kong for 11 years, and during that time came to Busan. This is the first time I've been back since then, since about 1986, and I see the place has changed hugely. But it's nice to be back. My paper is short, as I said, and it deals with a point about the difference between arbitrating a collision dispute or running it before the court. I thought I would have to have a collision photograph for you, and this collision occurred about 3-4 weeks ago in Ireland, where this little ship ran straight into a ferry running between England and Ireland. I don't think that whether we arbitrate or litigate this dispute is going to make much difference, because the captain was totally drunk, and so drunk, in fact, that he was taken to prison, and I was not able to interview him because of that. Anyway, that's by the by. As Michael has pointed out, certainly in collision cases, we may have no choice about whether we arbitrate or litigate, because often after collision cases, as you know, a ship may be arrested in order to gain the benefit of that particular jurisdiction, or to gain security. So we may have no choice, but if the parties, and usually, of course, it's the underwriters who are paying the money, they may be in London, they may not like the jurisdiction in which the collision occurred, maybe in Russia or South America, and they don't want to litigate their problem in that jurisdiction, then they may start talking, and as in the case I have at the moment, for a Korean client, the parties have agreed to arbitrate. We've made the guarantee subject to arbitration, and the dispute is going to be resolved by way of arbitration in London. The advantages, I think Michael has run over already, all the differences. Arbitration is private, and many clients like that, so they prefer to arbitrate. It is possibly cheaper. It depends on the type of dispute. If it's really contentious, both sides will inevitably, in London, under our system, we have a dual system of using counsel and solicitors. Counsel argue the case. They argue it before an arbitration panel, as well as before the court, or before the court. And so the expense is just as the same as it would be in court. So often there's no difference on cost. If it's a smaller dispute, then quite often it's easier, and as Michael's referred to, there is the small claims and the intermediate claims resolution procedure, which would be slightly cheaper. And the arbitrators are more flexible on the timetable. So that may be an advantage. If the parties are genuinely trying to negotiate a settlement, it may be beneficial towards the ultimate resolution if the panel is more flexible about timetables for disclosure and serving submissions and pleadings. But on the other hand, if you have an opponent who is determined to delay matters because they know they are going to be the paying party, then the arbitration panel is often pretty ineffective about forcing the pace, whereas the court is much stronger, has much stronger rules, and they use it, or the court uses it. But the major difference, as far as I'm concerned, and it may be because I'm a mariner, I'm slightly prejudiced about this, but it's from my observation also of how the court deals with collusion cases. The big difference is that in the court cases, you don't have a mariner making the apportionment, whereas in arbitration, you have the opportunity to appoint an ex-mariner, one or two possibly, to sit on the panel. Our Admiralty judge in London is not a mariner. I don't know any Admiralty judges in other jurisdictions. I'd be very pleased to hear whether there are any Admiralty or ex-seafaring people in the judiciary here in Korea. So the judge is hearing a maritime case, so he's going to hear a lot of facts about navigation, about the behaviour of the officers on both ships, because when he comes to apportion make his apportionment of liability, he has to, in his own mind, weigh up all the evidence. He has to assess the blameworthiness of each fault, and also its causative potency. By that we mean how causative was the particular fault committed by an officer. For example, one ship may be found to have altered course to port, but failed to sound 2 short blasts, which is the signal for I am altering course to port. But if that alteration of course to port was made in a gale, or when the ships were 3 miles apart, when such a signal would never have been heard by the other ship, then that fault is not causative, and is not likely to be found blameworthy. So the judge, on the other hand, an alteration of course to port in fog against the Rule 19 provision, which says don't, if possible, alter course to port, that is likely to be found to be extremely blameworthy, and is likely, depending on the facts, to be causative, heavily causative. So the judge weighs that in his mind and makes his apportionment. Now the point I'm making here is, how does the judge, not being a mariner, properly weigh in his mind the effect of these actions or inactions by the navigating officers? We have a system where 2 elder brethren, and they are senior mariners, sit on the bench with the judge. And before the 2 cases I'm going to mention, what happened was that those elder brethren would sit in full uniform, whether they were Royal Navy or Merchant Service, would sit next to the judge. They said nothing. They had no right of audience. The counsel who were arguing the case didn't talk to them or address them. But at the end of the case, the judge and the 2 elder brethren would go out of the door behind the court. They would retire, and the judge would then come back, probably 3 weeks later, to give his judgment, in which he would say, these are the facts I find. I have asked the elder brethren these questions. Was the alteration of course at collision minus 12 minutes a proper and seaman-like thing to do, or was the fact that this ship was doing 16 knots when the visibility was only 1 mile in this fairly narrow channel, was that a seaman-like thing to do? And so he sets out in his judgment written questions that he has put to the elder brethren. And then he says, the elder brethren gave me these answers, and he prints out the answers given by the elder brethren. And then he says, generally speaking, he would say, I accept that advice. And then he would make his apportionment and say, I find this ship was particularly at fault for A, B, or C, and I find 80-20, 70-30, whatever, in favour of one of the ships. Now, for me, the difficulty has always been, the thing that troubled me was, how does the judge, does he actually sit in a separate room, write out his questions, send them to the elder brethren, the elder brethren look at them, write the answers once they've conferred, give them back to the judge, and then the judge writes down includes these questions and answers in his judgment? Or does he, and I would hope he would, say to the elder brethren, let's go and have a coffee, sit down with them, and discuss the evidence, and say to them, well, you've heard all the evidence. What do you think was the most blameworthy, the most causative element in the build-up to the collision? And indeed, he might, I would hope, I would like him to, I'd like to be told by the judges. One day I will have the chance to talk to an ex-judge and find out. But he might even say to them, well, how would you apportion this? You as mariners, very experienced mariners, how would you apportion blame? So that he gets a feel from the mariner directly as to what the apportionment should be. I would be encouraged if that was the case, but I'm afraid we don't know, and I suspect it's not quite like that, because the cases show that the apportionment is a judicial decision. It's not an opinion made by a mariner, it's a judgment made by a judge. Well, the court obviously was quite concerned about the sort of concern I had, because in the Bowspring and Manzanillo, the judge commented on the fact that it was very important within the Human Rights Convention that the parties should know what was being said to the judge to influence him about the decision. Mr. Justice Clark, in that case, said that any consultation between the court and the assessors should be open as part of the assembling the evidence. Very shortly after that case, in the Global Mariner, Mr. Justice Gross actually set out what the procedure should be. And he said, what should happen is that after the evidence has been given, the judge should then discuss with the two parties the sort of question, or the questions which they thought, and he thought, should be put to the elder brethren for advice. Once he's had that discussion with the parties, then Mr. Justice Gross says that the judge should limit his written questions to the elder brethren, to those questions. Those questions obviously are put to the elder brethren, and the elder brethren will then come back and give the answers to the judge. The judge would then show those answers to both parties and give both parties the opportunity to say, we don't think that that question was properly put, or we could add another question which would be more relevant. And of course, each side is competing to try and get an answer from the elder brethren which favours their case. But they have the opportunity to comment on the questions and the answers that have come back from the elder brethren. The judge then considers that. He goes back to the elder brethren and says, this is what the parties comment about on the answers you give, and gives them the opportunity to say to him, okay, well, we think they're right about this, or they're wrong about that. But we don't hear about that, because the next step is that the judge comes back with his judgment, and in the judgment he will say, I have put these questions, these are the answers, and this is my apportionment. In my experience, the judge doesn't often change his mind about the questions that he puts to the elder brethren. So, in 2 or 3 cases that I've dealt with that have gone to trial, where this exercise has been given, or we've gone through it, the judge has appeared to ignore it. And they ignore it on the basis, I think, that he just sees that as further submissions arguing your claimed merit of your particular case, rather than looking at an objective assessment of the facts. Anyway, that's the way it is. So that's the position if we go to trial in court. If we take the case of arbitration, we avoid all that because we appoint one arbitrator at least, two if we can find them, and I'm afraid the weakness of my submissions about doing it this way is that there are a limited number of ex-seafarers who are arbitrators. But luckily, if we're lucky, we get two, and we have them sitting on the panel. They will listen to the facts as put forward by the witnesses to the case. They read the documents, and they also will listen to the expert evidence which is put forward by either side. In court, you can apply to the court to use an expert to argue submissions on navigation to support your case, but you have to get permission from the court, because the court says, we already have the elder brethren, they are our experts, they are experts of the court, so unless you can show that the expert you're going to bring has particular knowledge, say, of the type of ship, say the collision occurred between a jet foil and a ferry, the court may be happy to have evidence from an expert who can tell the court exactly how a jet foil operates, how quickly it can stop, how quickly it can turn, etc. So quite often you do get experts in the court. In arbitration, the panel is very reluctant to refuse a party to using an expert. So you appoint your experts on navigation, and they will argue their case on your behalf about speed or rate of turning circle or rate of turn a particular ship's case, etc. So the panel listen to that, and we've now got seafarers. We've got ex-seafarers who are listening to this evidence and expert advice. So you're confident that when a witness talks about the heading of his ship, that the mariner and the panel understand what he means by the heading of his ship. It's not the course of the ship, it's the compass heading of the ship at that particular moment. This is a fine distinction, you might think, but I have seen counsel get very, very confused about this difference in a trial, in court. And you think that if counsel gets confused, then a judge who is not a mariner may also get confused. So herein lies the difference. In arbitration, it's a mariner who's sitting and listening and will understand the facts better. And finally, when we come to the apportionment, we can be confident that we've got mariners making a judgment, in effect, when they apportion the blame between two other mariners. So basically, the difference is that in a trial, we've got a judge making a judgment, apportioning liability, upon the advice of a mariner. In arbitration, we've got mariners making an apportionment in a legal way, i.e. through arbitration. I think that's all I have to say. I think I have the point across. I told you it was short. But that gives me more time for Jonathan now to